Hello and welcome to Dialogue. I'm Yang Rui in Beijing. Last Tuesday, the U.S. Court of Appeals in Washington, D.C. ruled that the U.S. government had violated the rights of a Ross Corporation owned by Chinese machinery giant Sanyi Group when it rejected the company's bid to purchase 4 wind farms in the U.S. state of Oregon in 2012. The ruling is a win for foreign companies that confront national security concerns raised by the Committee on Foreign Investment in the U.S. How should we view the early victory for Sanyi Group? Is it significant? What challenges do Chinese companies face in foreign acquisitions? Joining us in the studio, we have Mr. Edward Lehman, the Managing Director of the Lehman, Lee and Xu law firm, Mr. Victor Gao, the Director of the Chinese National Association of International Studies, and Mr. Tao Jingzhou, Managing Partner of The Shed LLP China Practice. Before we start the discussion, let's have a quick look at this.
A historic victory. That's what Chinese machinery manufacturer Sanyi Heavy Industry is calling its successful appeal against US President Barack Obama. 2 years ago, the Ross Corporation, Sanyi's subsidiary in America, bought 4 wind farms in the state of Oregon. But the project was rejected by the Committee on Foreign Investment in the US, citing national security concerns, as the farms' locations were near a US naval facility's restricted airspace. US President Barack Obama then signed a presidential order to block the deal. Sanyi's quick response came in the form of a lawsuit. The case made it all the way to the second highest court in the United States. On July 15th, the court ruled in favor of Sanyi, saying the order, without due process of law, had deprived the company of its protected property interests.
The lack of process constitutes a clear constitutional violation. This ruling means that the order by President Obama is no longer valid.
Though not all agreed that the ruling could make the order invalid, the company and industry analysts believe it could open the door for other companies who've been turned away.
I think this ruling is reassuring for many foreign companies wanting to invest in the U.S. Now there is a way to pursue fairness and justice. Before this, rulings by the CFIUS couldn't be overridden by the law. This court ruling shows that companies are entitled to challenge CFIUS, which will make their black box operation more transparent.
The court also ruled that Sanyi will get another opportunity to hear and try to address the government's concerns.
If CFIUS is not doing a good job on explaining to the parties that filed why they're having concerns, then they need to improve upon that process.
Now, Chinese investors have overtaken the United Kingdom as foreign buyers of U.S. companies that come under the most scrutiny, as they are viewed by the U.S. government to have the highest percentage of national security challenges. The U.S. government says it is reviewing the decision. If it decides to appeal, it would go to the U.S. Supreme Court.
Welcome back, gentlemen. Why do you think this is an early victory for the Sanyi Group, Victor?
First of all, I think this is still very much procedural because the case is now referred back to the district court for kind of a retrial. And Sanyi and its subsidiary Ross will have another chance to present its case to demand for new discovery of information and evidence which is in possession of the U.S. government and try to have another hearing, I would say. Now, the difficulty for the U.S. government is what to do, whether it should cooperate.
That's my next question, Victor. Yes. That's my next question. But Edward, this early victory of the Sanyi Group will not make the presidential order invalid at this stage. Now, what are the other legal options on the table for President Obama?
The other options possibly, it's shrouded, this Committee on Foreign Investment in the United States, which is called CFIUS, that's what they refer to it as. You can have mitigation of what the findings are, and perhaps that was a good thing. I think that viewers should keep in mind, though, this whole order came out in 2012, an election year, and it was just right around the time Mitt Romney and him were battling. And so I think, and actually what happened in this particular case was that Sanyi did not file with CFIUS. And so by not filing with CFIUS, it automatically, there was some investigation by CFIUS, and then they tagged it, and then eventually the presidential order came out. So I think part of this might be Chinese companies operating within the United States aren't totally aware of a lot of different things. We find this over and over again. So I think this is not the end of it, certainly, no. But I think there's mitigation that could be had, and I think there's withdrawal. It seems like SANY does not want to withdraw, which is probably a good thing.
Mr. Tao Jingzhou, what's your take about the latest outcome of the legal battle? Do you think there will be a logjam outside the court? There will be a deal that's to be cleared by lawyers from both sides? What's your take?
No, I don't think that two lawyers are going to cut the deal soon. I think the remedy for the Obama administration is twofold. Either CFIUS will go to Supreme Court for appeal, or CFIUS can also ask the whole band of the appeal court to have a trial. You know that in this case, they only have 3 judges. They could ask all the circuit judge to compose a new tribunal to rehear the case. So I do not think that the CFIUS is going to give up so easily.
But it seems the CFIUS failed to deliver a clear definition about national security. You know, in this case, it's always the national security reasons that are cited by the U.S. government to protect their own businesses at home. Now, what do you think of this concern?
Now, first of all, in this particular case, the objects involved are wind farms, and in Oregon. So, what exactly are the national security considerations, going on in this particular case? I remember back in the 1970s when the United States wanted to export wheat or corn to China, there were some Americans actually seriously considering whether grain export to China had a national security interest. And Deng Xiaoping actually teased them. They basically say, well, the civilian side of the equation in China can eat the corn, but the military can also eat the corn. So how can you really say this is purely civilian, or this is dual purpose, or this is purely military? Now, in this case, wind farm is a wind farm. I think the Americans, as a global leader, should have enough confidence in themselves. Say, yes, wind farms are off the list from national security consideration.
But the wind farms are very close to the naval weapons training ground. I mean, that could be a very sensitive location, right?
And I think that's the issue. But I also would say that there's a large misunderstanding. I mean, SANY is a Shanghai publicly traded company. It's not a state-owned enterprise. I mean, I think that there's some confusion, and certainly with lawmakers and people who are elected
Excuse me, here are 2 issues. One is whether SANY is a state-owned. The other is whether it is sensitive due to the location, which is very close to the naval base.
Yeah, it's 2 miles with the wind farm. It's 2 miles from the base and 5 miles from the base. Each of these wind farms are located in. There is some concern. I mean, I understand that, but I'm not sure CIFIS is the right way to address that concern. I would imagine the military would say within 20 kilometers around the military bases you can't have private enterprises. The concern is that they can view somehow, Chinese could view these operations at the naval base, but that's hypothetical, really, and so I mean, it's hard for them to say.
Jingzhou, what do you make of the secretive review process? I mean, is it a black box process?
Up to now, I would say yes, it's very opaque, because CFIUS just tell you they are going to approve or not approve a transaction. So they do not give a sufficient reason for their refusal for a transaction. I think in this case, people speculate that because this wind farm is too close to the airspace of U.S. Navy, therefore they kind of turn down this transaction. But since there are no sufficient disclosure, people do not really know what's the fundamental reason for President's order to stop this transaction.
Victor, don't you think it is a little bit unrealistic for companies who want to acquire overseas businesses to know full information from the U.S. government, who always cites national security as a protection?
Yeah, in the U.S. case involving the CFIUS review, the problem for the overseas acquirers is that this whole CFIUS process is very much backloaded. It's not front-loaded. So you proceed on a commercial basis for an M&A deal. Then you move on to the financial basis on the M&A deal, and CFIUS is still quiet. It's off the radar screen. And then at a very late stage, you need to trigger that process for the CFIUS review, which is a kind of ad hoc, interdepartmental entity. Then you do not know what will happen in the CFIUS review. There is not clear guidelines. For example, I remember I was involved in the CFIUS review for the CNOOC proposed acquisition of Unical back in 2005. The Wall Street bankers, the Wall Street law firms, even including the U.S. government entities, all the way up to the White House, claimed that there should be no problem in the CFIUS review. They basically say if you put top dollar on the table, the deal is yours, because the deal involved 3 publicly listed companies, Unical, CNOOC, and Chevron. But eventually it became very political. And then this so-called national security interest was really elevated to the very top. And eventually, after spending millions of dollars on the Unical deal, after beating up on the chest by all the intermediary firms, CFIUS came up with a kind of a non-action before the members of Congress actually killed the deal. Right. So I would say this whole CFIUS process should have a much clearly defined guideline. The Americans will be better served if they basically say this is a short list of propositions or situations where we do not welcome foreign investment. Clear. Then people will have a better guideline.
Right, and China is probably better with that too. They have a prohibited area of foreign investment. I mean, so it is more clear. I agree with Mr. Tao that it should be more clear. There is a process. I mean, the problem I see sometimes, and we've been involved in the CFIUS process as well. In 2005, in action, they actually withdrew. I mean, the CNOOC withdrew in that particular case. Just keep in mind, though, since it's been around since 1975, so I got 19 years. There's only been 2 presidential stoppages, and actually, one was under George W. Bush, I believe, and the other one is the second one under Mr. Obama. Generally, they withdraw a lot of them. There were only 114 cases that were cited in 2012. 45 of those were reviewed. A number of them, about 20, were withdrawn. So, I mean, I agree. I think it should be more transparent. There's really, the Board of Treasury is involved. It's a very confusing process, even for Americans to understand. And like Professor Tao said, is that it's a moving target. What's considered political? Is it pork? Is it naval bases? Is it oil? It's very difficult to know what's political. And so, if it's not clear, then that's the reason why the Court of Appeals made such a judgment. And the other thing that Tao Jinzhou was talking about was the evidence. We don't have evidence. They don't. I mean, Sani is put in a difficult position because they can say, "Hey, national secrets. We can't give you the evidence."
This is what we call the issue of information deficit.
Right.
Not quite in favor of Sanyi Group. Now, Jinzhou, why do you think a majority of the Chinese companies who want to go international and seek overseas acquisitions hesitate a lot and even stand in awe at the order from either the White House or instructions from the CFIUS about so-called national security? Is that a sole legal concern that would bar most of Chinese enterprises from having a successful acquisition?
No, I don't think so. As Mr. Lehman just mentioned, there are all 2 transactions which were vetoed by U.S. President. Most of the transactions will go through without any problem. Maybe with the CFIUS look at those transactions, but didn't veto such a transaction. So, but CFIUS is certainly a kind of a big threat for Chinese companies because the political regime differences make the U.S. government even more vigilant towards any kind of transaction made by Chinese companies. I just want to mention that as to the national security, is also very difficult to define. They cannot really publish a list that say those are national security projects for which foreign company cannot invest. It's very difficult to do this, I think, for any government.
Thank you very much. When we come back, we'll take a closer look at why Huawei, a telecom infrastructure giant, has chosen to give up its bid in the overseas market, such as the U.S., to have its proper market share. Stay with us. We'll be right back. Welcome back. Victor, what do you think of Huawei's failure to win its proper market share in the U.S.? Is it also because of national security?
Well, I would say before the Edward Snowden incident, the United States was very much on the Chinese throat, and especially in terms of accusing Huawei of aiding and abetting in cybersecurity espionage. However, I would say now that we have the benefit of the Edward Snowden case, I would say probably the American authorities have been looking at Huawei very much out of their own stereotype of how much they can do with the equipment manufacturer. Now, if the Chinese government adopts the same argument as the Americans do with regard to Huawei, what will happen to Cisco, for example? What will happen to Motorola? The Chinese government can always use these magnifying lenses and check them out and say, oh my God, there is a national security consideration. We should ban these companies from the Chinese market. Then you end up with a trade war. Both China and the United States suffer as a result. So I would say if the Americans are worried about Huawei in terms of national security consideration, pinpoint exactly where are the violations and penalize them for that. But for the rest of the operations, the U.S. market should be a free market. So I would say that the Americans should really measure their kind of a concern in a more accurate manner and avoid, penalizing foreign companies in such a way which may eventually trigger a trade war.
Edward, what do you make of the Chinese efforts which may be viewed as retaliatory in ordering all the major state-owned enterprises not to use overseas servers in their computer network?
I think that's to be expected, this kind of thing, and this is exactly what Victor Tao is saying, which is when you start escalating these things, then where does it end? It only ends in tragedy. And really, what are we about? We're about free markets. America should really stand, in my opinion, for free markets. I think even Colin Powell, the Secretary of State, he said that investing money is a coward. Investment of money is a coward. They're afraid of any place that seems unstable and doesn't want you. We need $3 billion of investment every single day to keep America's government afloat. We should be encouraging these things. I understand national security concerns. I do. But we should be a place that encourages investment. That's what we're all about. America's that idea. And so I understand retaliation, and I think it's to be expected. But is it a long-term solution? No, I don't think it is. I think that America is looking at it. They're going through due process, and I think that they'll be successful ultimately, perhaps, Sunny.
Jingo, when we look at the overcapacity of solar panel as well as other industries, do you understand the current boom for Chinese companies to go overseas and seek acquisition and merger? What do you think of the current zealous Zoom? The zealous boom and the current passion?
Yes, I think it's become a kind of fashion for Chinese companies to invest abroad, because the Chinese company wanted to become an international player, and in order to do this, either you do organically by your own aiding force and marketing people, or you acquire an existing company. By acquire existing company, you have a full management team, marketing, and everything else in place. Is kind of up running from day one. So that's why Chinese companies become and more interested in acquire foreign companies, big or small, in different parts of the world.
Now, Edward, Lenovo, the world's largest PC maker, is waiting for two decisions by CFIUS on its acquisition of Motorola's handset business from Google for $2.9 billion and the purchase of IBM's low-end server business for $2.3 billion. CFIUS is also reviewing Morgan Stanley's sale of its oil trading business to Russia's Rosneft, whose chief executive Igor Sechin is among those on the U.S. sanctions list for the standoff against Russia over Ukraine. Now, what do you make of the future?
Again, I think that this is something that they have to go through. I mean, Lenovo went through this already when they were approved. I mean, to purchase the first unit from IBM. So they've been through the process. They should know the process. I think, to Tao Jinzhou's point, is that a lot of these companies come in largely unprepared, because they're. And even if you look at our elected officials versus Chinese elected officials, most of them are engineers, economists, whatever. That's their background. Most of the lawyers in the United States in the Congress and whatnot. So we look at it more as a legal function. When they go to buy a business, they're not really. I think Chinese businesses are not so plugged into this idea of laws, policies, and regulations, and that's the driving force. But no, I think the future with CIFAs, is opaque. Right now it is opaque. There's no real clear person who's in charge. That's why Barack Obama's name is the only official on it. And so I'm not sure the process. I think it can be used as a political football, which is not always positive.
Now, Victor, since an increasing number of Chinese companies are seeking overseas merger and acquisition, do you think they are prepared? Now that brings us back to what happened in the early 1980s when Mr. Gu Mo, Vice Premier, who's in charge of development of science and technology, said, 如果你与狼共舞，必须要学会跟狼一样的叫. If you want to dance with the wolf, you have to howl like a wolf. Now, what does that mean in terms of the acquisition merger?
Well, I would say it takes two to tango. Globalization is one of the mega trends in China, and it's irreversible. The Chinese companies are going abroad. They'll be more and more plugged into the international trade framework. But on the other hand, in the case of the United States, I think the U.S. government, the U.S. political forces, and the people in the United States need to come up with a firm conclusion that direct foreign investment into the United States is a good thing. It's not a bad thing. It's not an evil. They need to embrace foreign investment in the United States, because the more foreign direct investment into the United States, the more they will help create more jobs in the United States, and they will promote the U.S. economic growth in a more healthy manner. So this should be left undisputed completely. And this should not be used as a political game by one political party against the other, or vice versa, and try to really, create hysteria among the people about foreign direct investment. Of course, national security consideration will be important, but they need to be carved out very carefully, and the U.S. government need to demonstrate enough confidence in the country themselves to be worthy of a global leader in its own capacity.
Jinzhou, for the very first time, the Chinese companies have overtaken the UK in, being reviewed by CFIUS, since more and more Chinese companies want to get listed in the New York Stock Exchange. Now, what do you think of the issue of a class action? Do you think that most of the Chinese players are well prepared for the legal battles ahead?
I think some Chinese companies are not fully aware the legal cost to be listed in the U.S. because U.S. people seems to be more, legally minded. They are not going to hesitate to initiate the procedure such as a class action you just mentioned. So they have to really budget a big expenditure for the legal cost in the future in the U.S. if you want to get an IPO or other activities in the U.S.
Right. What do you think of the consequences arising from the lawsuit against the Chinese companies in the New York Exchange market?
Well, it is without any doubt that the United States is probably the most litigious country in the whole world. In terms of per capita, lawyers per capita, the United States has the highest, a ratio. It's not all bad. I'm trained as a lawyer. I'm licensed in the state of New York as an attorney of law, and many of my classmates are now practicing law firms or in the court system. However, from the Chinese perspective, for example, our legal document is very thick, several pages long. But then in the U.S. document, it's very, very thick. Default provisions are always very, very comprehensive. This is a mind change for the Chinese companies, especially for the older generation of managers who do not have a lot of exposure to the international transactions, especially those in the United States. So we need to educate ourselves. And I would say U.S. law firms, international law firms operating in China will have a very, very role to play. But on the other hand, I think, in terms of the U.S. government's behavior, they need to create an environment and a system whereby it will be easier and more user-friendly for foreign investors to make investments in the United States.
Edward, what do you make of the significance of this case, that it seems more and more Chinese companies would seek to protect their interests with the American laws, because previously they chose to be silent. They were not prepared to use laws to defend the laws.
Right, and that historically that's what we've seen. I mean, there were ITC, International Trade Commission cases that Chinese never responded to when the things were there was in-rem jurisdiction over the objects. Now they're participating in that, and they're participating in it. So I think that that's going to be very significant. When you have companies like Baidu, Sina, Sohu that are publicly traded, and then Alibaba is soon to be publicly traded, it's going to be very interesting because they're going to be held by the standards of American laws, policies, and regulations in order to conduct their business in China and around the world. And so it's going to be a very interesting outcome for that. But I think it's a good thing. I mean, this is what Professor Tao was saying, which is that we need to drop the barriers, we need to be fully comprised of the laws, policies, and regulations and go forward, not fight each other on a political basis, but on a legal basis where it's all transparent and clear. And that's why I think Sani did a good thing with this.
Look, look, gentlemen, here is yet another embarrassing issue. If all of the media giants like Baidu, Sina, Tencent, all get their companies listed in the U.S. stock exchange market, then what about the overseas ownership of the Chinese media? Then how do you assess the impact of such a foreign ownership of the Chinese media? We'll come back to examine these critical issues on another edition of Dialogue. Until then, I'm Yang Rui. Goodbye.